This animated diagram compares training requirements for an EMT against a licensed cosmetologist. The EMT counter stops at 33 days. The cosmetologist counter continues climbing, reaching 1,500 hours. That is roughly 11 times the duration required to manage life-threatening medical emergencies. During a 2019 business session with state governors, the president explicitly pointed out this exact regulatory anomaly. This mathematical disconnect forces us to ask whether the primary function of this massive regulatory system is consumer safety or something else entirely. Formal beauty regulation emerged in the 1920s and 30s. Early practitioners navigated genuine physical risks, applying harsh compounds and utilizing complex electrical apparatuses on clients. Modern occupational licensing possesses a dual nature. It is a vital mechanism for preventing chemical injury and infection, and it simultaneously operates as a structural barrier to economic participation. We will dismantle this regulatory web using empirical economic data, trace its demographic impacts, and examine how understanding administrative law serves as the ultimate vocational defense. To survive today's beauty industry, technical mastery is no longer enough. A professional must navigate both science and the complex mechanics of law. The bedrock justification for licensing is the prevention of communicable disease transmission. Professional beauty services create specific opportunities to spread blood-borne pathogens and fungal conditions like tinea capitis if pathogens are not actively neutralized. Shared salon implements, specifically pedicure basins, nail tools, and facial instruments, create documented, scientifically valid public health vulnerabilities if improperly sanitized between clients. At the federal level, the Modernization of Cosmetics Regulation Act of 2022 established a crucial baseline, expanding FDA authority over cosmetic product safety, mandating recalls, and requiring adverse event reporting. Foundational sanitation protocols and chemical safety laws have genuine medical validity. The critique here is not directed at basic safety, but at the sprawling administrative apparatus built on top of it. To evaluate the reality of regulatory bloat, we turn to the Institute for Justice's 2025 Clean Cut study. Researchers found that states with heavier, more burdensome licensing requirements produce health inspection outcomes that are no better than states with lighter requirements. This chart directly compares the financial barrier to entry against the economic return. Average $16,000 tuition and $9,900 debt sit opposite median earnings of $16,600. Because of this inverted model, 32% of cosmetology students fall at least 3 months behind on loan payments. A Department of Education analysis projected that over 92% of all cosmetology and related grooming programs would fail a proposed earnings accountability test. The mandated regulatory burden actively drives students into systemic financial vulnerability without delivering any commensurate improvement in consumer health outcomes. This diagram illustrates the regulatory layering problem. A single school or salon owner is surrounded by simultaneous obligations from distinct authorities: state cosmetology boards, NACAS, the Department of Education, and OSHA. At their intersections, compliance burdens compound. The owner must simultaneously manage hour tracking, Title IV return calculations, and daily sanitation logs. This complexity creates an environment ripe for regulatory capture. Active market participants use the power as licensing boards to suppress new competition and protect incumbent businesses. In the landmark 2015 case, North Carolina State Board of Dental Examiners v. FTC, the Supreme Court ruled that state licensing boards dominated by active practitioners are subject to federal antitrust law. This overlapping regulatory web is not a broken system. It is a system functioning exactly as economically designed, to protect incumbents by raising the cost of entry for newcomers. The roots of exclusionary licensing trace back to Jim Crow-era barbering codes. These were explicitly designed to suppress Black economic competition in a trade African Americans had historically mastered. That historical template evolved. Today, licensing laws use race-neutral language to achieve similar exclusionary results by mandating English-heavy documentation and complex testing. In the modern nail salon industry, which was heavily shaped by actress Tippi Hedren's work with Vietnamese refugees in the 1970s, workers face compound vulnerabilities. They must navigate a rigid regulatory environment despite high rates of limited English proficiency. A 2023 study by the Federal Reserve Bank of Minneapolis revealed that licensure reduces foreign-born employment in a licensed occupation by nearly 20% relative to native-born employment. Arbitrary training hours and complex English testing act as a structural wall. They convert language and economic status into insurmountable barriers to entry for marginalized groups. Because state boards wield extraordinary power, including unannounced inspections and emergency closures, navigating this asymmetry requires professionals to invoke their constitutional rights. Under the 14th Amendment, as established in the Supreme Court's Board of Regents v. Roth decision, a professional license constitutes a protected property interest. Courts use a three-part scale to lay the private interest against the risk of error and government interest. When an emergency closure order is issued, the scale tips heavily towards the private interest. Licensees have a constitutional right to written notice before adverse action. Under Title VI of the Civil Rights Act of 1964, individuals with limited English proficiency are guaranteed language access rights and translated documents when facing regulatory action from federally funded entities. State Open Records Acts provide a strategic defensive tool, allowing licensees to legally acquire inspector notes, complaint files, and board meeting minutes before a disciplinary hearing. These constitutional rights and legal protections are functionally meaningless if the licensee does not know how to invoke them during a stressful regulatory encounter. The traditional beauty education model fails its students by treating legal, regulatory, and due process rights as secondary concerns subordinate to technical skills. This 5-pillar graphic outlined the integrated compliance curriculum pioneered by Louisville Beauty Academy and Tran University. It builds from the ground up: sanitation science, law and regulation, due process, business ethics, and student rights. Treating administrative legal knowledge as a core professional competency protects both the worker's property interest and the consumer's safety simultaneously. The productive response to an imperfect and sometimes exploitative regulatory system is not cynicism or fear, but informed, documented professionalism. A rights-aware professional shifts the power dynamic. They become an empowered advocate for policy reform, language access, and structural change within their own industry. Technical skill may create the livelihood, but rigorous administrative legal knowledge is the only tool that can protect it.